Agent Orange is one herbicide of many that was used in Vietnam. Some people refer to them as the rainbow herbicides, and that's pretty accurate because there was herbicide orange, as it was referred to back then, herbicide blue, herbicide white, herbicide pink, herbicide purple, and herbicide green. So those were literally the rainbow herbicides. Agent Orange is the one that everybody hears about. They get the impression that you must be exposed to Agent Orange in order to get the benefits that many Vietnam vets get if they come down with a host of disabilities. Lung cancer, leukemia, prostate cancer, heart disease. There's a whole list of diseases that are presumptively service-connected for Vietnam veterans. If you're in Vietnam, if you were in Vietnam, then you are presumed exposed. So that takes care of the in-service event of exposure. If you get one of the disabilities on the list of presumptive disabilities, then that disability is presumed related to the exposure. So that's kind of how benefits for Vietnam veterans work. It's not accounted for weed control activities or your average spraying of foliage on the rights of way or the typical places people would use herbicides back then. The quantity was outrageous. Before we can get to that, it helps to understand what a herbicide agent is. So like I said, everybody thinks it's Agent Orange. Funny, the regulations that came from the Agent Orange Act in VA's regulations, they never mention Agent Orange. They refer to herbicide agents. So you have to understand what a herbicide agent for the purpose of the presumptive service-connected disabilities are. If you look in VA's regulation where it talks about what disabilities you can get benefits for if you're a Vietnam veteran, it will tell you that if on active duty you were exposed to a herbicide agent as defined at Title 38 CFR Section 3.307A6, and you get one of these disabilities, VA will presume it's related to that exposure. So that chunk right there says you have to be exposed on active duty to one of the defined herbicide agents. So then you go to the other regulation at 3.307 and it tells you what a defined herbicide agent is. It tells you that 2,4-D, 2,4,5-T, and its contaminant dioxin, cocodilic acid, and picloram are herbicide agents for the purposes of VA benefits. Agent Orange was a 50-50 mixture of 2,4-D and 2,4,5-T. Both of those herbicides were regular herbicides in their own right. In Agent Orange, they were simply mixed at a 50-50 ratio and sprayed. The 2,4,5-T based herbicide is the one that was contaminated with dioxin. Now, the specific dioxin that it was contaminated with is short for 2378-TCDD. So if you look in VA's regulations, it'll tell you 2,4-D, 2,4,5-T, and its contaminant 2378-TCDD. It stands for tetrachlorodibenzoyl-paradioxin. That's one of many dioxins, but it's the most potent dioxin on the planet. It's the toxin that scientists use to measure other toxins against. It is not what you want to be exposed to. So those two herbicides made up Agent Orange, 2,4-D, 2,4,5-T. 2,4,5-T was contaminated with dioxin. It's important to know that herbicides green, pink, purple were all various formulations of those herbicides, with one of them being nothing but 2,4,5-T without the other herbicide, 2,4-D. Cocodilic acid was Agent Blue, which was about 33% arsenic, and picloram was an Agent White. So those agents made up all of the rainbow herbicides. So you would think, all right, once we found all that information, that it would be relatively easy to help veterans get benefits. That's not the case. VA has a list of places that DoD has acknowledged that it used what they call tactical herbicides. The problem there is when you go looking at VA's regulations, the statutes, the history, you don't find anything called a tactical herbicide or a commercial herbicide. As I just said, VA regulations certainly don't define it that way. It's what agents you were exposed to. There's no such thing as a tactical herbicide. There's just a herbicide used in a tactical environment. VA wanted people to think if you used it in your front yard, it wasn't going to be dangerous. But if you used it in Vietnam, then it can cause all kinds of disabilities. That's the level of idiocracy that went into some of these claims. And that's what we had to get over to start being successful with these claims. because this was a deep-seated mindset through all of VA. There's plenty of VA employees still to this day that truly believe that there is a difference between tactical herbicides and commercial herbicides, when in fact there's not. It just depends on what agent you were exposed to. So that took a long time. We would file these appeals up to the Board of Veterans Appeals. They would get denied. The board would say these are commercial herbicides without addressing our evidence, without citing to anything where that mindset comes from. So we had to appeal these cases into court, which we did. The court saw through the BS, and we've been very successful, at least at the level of the Board of Veterans Appeals, which I think is probably the most important level for now, to get them to stop denying these cases on the false assertion that what you were exposed to was just a commercial herbicide. And so we have not seen a board denial on those grounds in some time. We've actually had plenty of decisions here lately that conceded exposure to herbicide agents as defined in the law, and service connection has been granted. Now, it's not across the board, but it used to be 100% denials. It's no longer that anymore. And so that's a huge step. One would think beyond that, well, then why won't VA just acknowledge all this? One, you still have that mindset in some places. Two, they were home to a number of things. And we're talking at least a 30-year time span. So you're talking tens of thousands of people. It's just something the government doesn't want out of the bag. And they're willing to deny veterans' claims to keep it in the bag. But the facts and the law, as applied to those facts, are on our side. This isn't something that should take an act of Congress, although Congress could act. This is something that somebody with a little bit of knowledge, the use of these herbicides, and what the law says about them, can look at these facts and go, yeah, we have to grant these folks benefits because they can show the exposure. They can show the exposures to something that VA defines as a herbicide agent. And if they have one of those diseases listed as presumptive, then it should be an automatic service connection. Now, that doesn't mean there aren't other disabilities that may qualify. Remember, I'm just talking about herbicide agents. Why do we go down that path? One, because we know the exposure's there. We have laws that are beneficial already to those folks. So it's the low-hanging fruit. It's what's affecting the most people. But you may have somebody with a cancer that's not on that presumptive list. That doesn't mean that case is going to lose. It's still a matter of getting medical opinions for some of these cases if we can show the link to those exposures. But we've been successful at a number of those disabilities, whether they're on the list of herbicide-related disabilities or not. So that's kind of our approach and the reasons for it. Some people may want to know what disabilities they might be able to get benefits for some of this exposure. A good starting point would be what disabilities are already presumptively service connectable to herbicide agents like Agent Orange. Those are the ones that are defined in VA's regulations, that for all Vietnam veterans or anybody else that VA actually concedes herbicide exposure for, like somebody on the Korean DMZ or nowadays Thailand or a few other places. I can't guarantee you I can name them all off the top of my head because the list has gotten fairly significant over the years. Prostate cancer, lung cancer, leukemia, diabetes, heart disease. There's a whole list of what's called soft tissue sarcomas that are all relatively rare. There's some skin disorders that are hard to pronounce. There's peripheral neuropathy, depending on if it was onset within a year of the exposure. If anybody wants to look it up, it can be found at Title 38 CFR, which stands for Code of Federal Regulations, 3.309 subsection E. The rainbow herbicides, people in Vietnam, should be able to get service connected for that particular list with no need for a medical opinion. That's what the presumption does. What do you need for service connection? You need an event in service, a diagnosis of what you're claiming, and a medical link between the two. The presumption of exposure for Vietnam veterans takes away that need for the documented in-service event. The presumption of service connection takes away that need for the medical nexus between the two. They just presume that it's that way. So those two groups should be equivalent. It's not to say they always play out like that in the claims, because they don't. You still get the presumption of service connection. You don't need a medical opinion to show how the conditions related to the exposure. But we see the board remand for that very thing because they somehow missed that point. So beyond the list of disabilities, what else could you get service connected for? Well, you have the list. You have what I think is the definite exposure to those herbicide agents, but you also have the exposure to a lot of other things, maybe certain levels of nerve agent, mustard gas, low levels of radiation. Mustard gas, you're going to know if you get exposed to that. They would test that on people's arms. They would put a drop on people's arms and it would immediately blister up. If you put that same drop in someone's lungs, well, they're having a bad day. You've got a solid case for just about any cancer or autoimmune related disease, possibly heart disease, because with Vietnam vets and Agent Orange, you've got heart disease on the list of presumptive conditions. You've got diabetes and all of its complications. So there are some systemic diseases that are not cancerous that may fall into that category. A number of autoimmune related diseases, in my opinion, because a lot of those exposures, while they may not cause all those cancers or diseases on the list, they may very well cause a number of autoimmune related diseases, especially when mixed in with other exposures to things like PCBs. The bottom line is, if you have those disability not on that list, you're still going to have to come up with a medical opinion linking it to the exposures. But if you can get your head wrapped around and have evidence of the exposures, then it's going to be a lot easier to get a medical link between that exposure and the disability, especially if you're going to a physician that understands what various chemicals can do to the body. Here you're talking a number of various chemicals all at once. I would not persuade somebody not to file a claim just because you don't have a disability that's on the Agent Orange list, because we've gotten plenty of benefits for folks that have disabilities that are not on that list. It's usually an act of Congress. And so it takes some pretty big movement inside the government, whether it's inside VA itself or whether it's through Congress, to get something presumptive. If you look back at Thailand, for example, when all the claims started about Thailand and the evidence come forth that herbicides were used there, VA initially said those are commercial herbicides. Even though they had no evidence that they were commercial herbicides, there was direct evidence that herbicides from Vietnam were used on Thailand. But VA used the excuse that they were commercial. Well, VA's done the same thing here. So as long as they can paint the picture and the belief to themselves that this is not a herbicide that counts for the presumption, well then why would you make it presumptive for the exposure if you don't think or can convince everyone that the exposure itself doesn't qualify for the presumption because it's some other type of herbicide? That's basically what VA's done. You have to kind of trace back where the phrase commercial herbicide came from. When Vietnam was over and people started getting sick, Vietnam veterans brought a lawsuit against the chemical makers that made Agent Orange and some other things. And in defense of that lawsuit, the term commercial herbicide in reference to those specific herbicides was coined. And it somehow just got embedded in VA's groupthink process that there is a difference. And it worked for decades. People that were not in Vietnam that were exposed to these things file claims or get them denied. There's been tens of thousands of claims denied on the false notion that they were exposed to just a commercial herbicide and not a tactical herbicide. That's been part of the biggest fight, is convincing VA that their mindset just holds no water whatsoever and that these are the same herbicides that was used in Vietnam. But that's also why we are trying to win these cases on the facts and the law, because eventually the dam is going to break and they're going to realize that they're going to have to concede this exposure. And whether they make the presumption internally through a rule change or through Congress, we're going to keep at it until it happens.